or a few seconds, I should say, to get logged into the webinar. All right, looks like we have a good group joining us today. See the number of participants continues to rise. Once it stables off, I will get things started. All right, that looks like a good spot. So welcome to the Quad Cities Chambers webinar. It's titled COVID-19 Legal Issues Impacting the Workplace. It's featuring Matt Pappas and Allison Wright. It's sponsored by Pappas Wright, attorneys at law. We really appreciate them. They're a premier management, labor, and employment law firm serving both Iowa and Illinois. At the Quad Cities Chamber, we believe in creating a prosperous regional economy where all can thrive. We fulfill this vision by facilitating business growth through placemaking, talent development, and attraction, as well as economic development. As we've done throughout the pandemic and will continue to do, the Chamber provides resources, advocates for your interests, and helps build your network. We know that workforce is a #1 concern, and Pappas Wright will help address some of the tough questions you're facing related to COVID-19 in your workplace. We'll also keep you informed as new guidance is announced in the coming weeks. If you're looking for kind of context as to where things are happening in the Quad Cities economy, I'll point you to our website. We just released our quarterly market report that gives a lot of insights into various industries and trends and economic data. So encourage you to go that direction. And as always, this webinar will be recorded and available later today on the Chamber's website. We will also take questions throughout the webinar. So please type your questions in the Q&A box and we'll get them at the end of this presentation as time allows. So now it's time to introduce today's speakers. Matt Pappas is the managing shareholder, and Allison Wright is also a shareholder of Pappas Wright, PC. Their focus areas include management, labor, employment matters, and litigation with private and public sector clients, including local and national businesses, colleges and school districts, hospitals, medical corporations, municipalities, and financial institutions. Matt and Allie assist their clients to navigate the complex management, labor, and employment issues that arise every day in the workplace. So Matt, Allie, thank you so much for being longtime Chamber supporters and for taking time to share your expertise with our members today. I'll turn it over to you. Thank you.
Thank you. Thank you, Paul. Good morning, everyone. Our staff has spent countless hours trying to grapple with COVID-19 rules and regulations, not only on a federal level, but being in the Quad Cities, also having two ideologically opposed states, Iowa and Illinois. Illinois has over 96 executive orders concerning COVID. A lot of what has been said is nuanced legalese. Whether the federal government has the power to compel vaccines is one question, but our job is to inform and instruct what we know today. And the things have changed a lot from the FFCRA, which was promulgated by President Trump on April 1st, 2020, to President Biden's promulgation of vaccine mandates, September 9th, 2021. This is a court-intensive process, and we know vaccine mandates will be along for the ride. In fact, employers and employees are already settling in for a fight. Arizona already has filed suit to prevent the president from such a sweeping promulgation of law. The Supreme Court held in the case 1989 case of Cruzan Director versus Missouri Department of Health that a competent person has a constitutionally protected liberty interest in refusing unwanted medical treatment. This right isn't absolute. If there is a sufficiently compelling government interest, this constitutional right can be overcome. Also, over 100 years ago, the Supreme Court had ruled on a similar measures in the 1905 case, Jacobson versus Massachusetts. The Supreme Court upheld a state law requiring either vaccination or paying a small fine. People could still refuse to be vaccinated, but the state could impose a monetary penalty. That dusty old case is now being used for the proposition that federal government can't do what it's doing today. So what's going on today? That's what we are here to talk about. I will be back to speak with you all regarding the religious exemption, incentives, and surcharges. It's time for me to introduce Allison Wright, my partner in our firm, who is an expert on COVID-19 related laws. Thank you.
Thank you, Matt. TGIF to everyone. Thank you for having us today. We're excited to be here. As Matt mentioned, our clients and employers everywhere have so many questions about COVID, and the legal landscape, as everyone knows, continues to change. So the questions continue to emerge. Since we planned even for this seminar a number of weeks ago, we've seen vaccine mandates come down at both the federal and state level in Illinois, and the impact has been huge. So today, we want to cover some of the most pressing legal issues and hopefully help fellow chamber members prepare to the extent we can for what's coming next. Now on this slide, as you can see, it's our roadmap, and we're going to cover 4 main sections today with lots of information packed into each one. The first is what we like to call at the firm the Quad City COVID chart. It's just going to provide an overview by jurisdiction of the current rules in Iowa and Illinois, and also at the federal level. Now, this will most certainly include reviewing vaccine mandates, of course, and what companies those cover at this time. Of course, any good rule or mandate must always require us to look at exceptions. So today we are going to do that. And we're going to talk about the 2 main exceptions to mandates that apply under state and federal law. Those are disability and religious exemptions. And after we review that process, we're going to talk about incentives and surcharges, how those apply to vaccines or failing to get vaccinated. And then lastly, we've accumulated questions from chamber members, and we're going to walk through in a Q&A format some of the most pressing issues clients are facing at this stage in the pandemic. And as Paul mentioned, please feel free to throw questions as you have them in the Q&A, and we're going to go ahead and address those at the end. But before we get started with the legalese, a quick note for everyone today. We have included here a disclaimer about the topics discussed today. Being situated in the Quad Cities, we know that the current rule books on either side of the bridge are quite different. And today we are simply making recommendations based on what that current legal framework looks like. So in short, we would kindly ask that nobody please shoot the messengers as we work through what laws and rules we have to work with today. Now, this very first slide includes a summary of a lot of what we're going to break down for you. You'll see here in the Quad Cities, we have 3 jurisdictions usually at play. Those are our respective states of Iowa and Illinois, and then of course the federal rules. And this chart summarizes vaccine and mask mandates we know of as of today, September 17th. So we're going to dive into them each in a little bit more detail. And I'm going to start with our federal standard. Last week, the Biden administration announced a series of new vaccine mandates that impact many employers throughout the country, and of course here in the Quad Cities. For everyone except for federal employees, the standard includes a requirement that employees get vaccinated or get tested at least once per week. Federal employees do not have the option to opt for testing. So as you can see here on this slide and onto the next slide, the new federal vaccine mandate applies to federal employees. And perhaps the largest one is going to apply to what's called large employers, defined as employers with 100 or more employees. This mandate is estimated to impact 80 million workers in the United States, or about 2/3 of the country's workforce. Also applies to federal contract workers, healthcare workers who have Medicare, Medicaid contracts, and then employees at things like Head Start programs and Department of Defense schools. It is important to note that Biden's announcement last week put us on notice as to who will be impacted, but we don't yet know when the official rules will be released. On the far right side of this chart, you're going to see a status column, which demonstrates what we do know about the vaccine mandate for those particular populations. And you'll see we have quite a bit of information still forthcoming. So in these charts on this slide and on the next, I've compiled what we do know, which is who will be impacted and which federal agency will be promulgating those rules. And like the large employer rule for employers with 100 or more employees is expecting to see the final rule come from OSHA by way of an ETS, an emergency temporary standard. And DOL officials said just last week, they do expect that rule to be out in the coming weeks. Whether or not that happens, we won't know until we see that come through, but that is the expectation. This is the slide with the final 2 categories of impacted groups from the federal mandate. So based on those federal mandates, what are we recommending right now? We do recommend chamber members do 5 things right now. First and foremost, determine if you are covered by that federal mandate. Do you have 100 or more employees? Are you a federal contractor? If you're not sure whether you're covered by this, I do recommend you consult with your legal counsel. And then secondly, determine what your policy is going to be. Even if you are subject to the mandatory vaccine requirements, there are still some discretionary components to be decided as an organization. unless of course somehow those are eliminated in the final rules. But based on the president's announcement last week, it does appear businesses are going to be able to decide between two policies, either a mandatory vaccination policy, which is subject only to religious, disability, or other legal exceptions, or a mandatory vax or get tested weekly policy, which allows employees to either get vaccinated or submit to at least weekly testing. Now, the third thing I recommend you do is identify your vaccinated and unvaccinated populations. So for clients who've already begun this process, I believe they would tell you this can be quite burdensome and time consuming. For now, the final rules are not yet released, but the DOL is saying that they are coming quickly. So I would begin compiling that information to identify who your vaccinated and unvaccinated populations are, so you can make the next move consistent with whatever policy you choose or whatever policy is implemented. And then of course, once you make those determinations, I recommend you evaluate the resources, policies, and procedures that you do have. Do you have a vaccination policy? How about a testing policy? Do you have religious or disability exemption forms? Do you even need them? Do you have a process for compiling vaccination cards? Do you have a process for getting employees tested? Who's going to be in charge of monitoring the weekly results? These decisions have proven already to require a lot of different resources, both internally and externally. So I would recommend that this analysis start as soon as possible if you are touched by the federal mandate. And then lastly, of course, I recommend you track the final release of applicable rules. As I mentioned, we know the general gist of the vaccine or the testing mandate, but we don't have the final rules from OSHA or the other agencies. So I would recommend you track the progress of those rules as they're released. To the extent there's additional requirements or nuances that you need to address, it is of course better that you know about them as soon as they become available. Now, shifting gears a bit to Illinois, I'm going to review the vaccine mandate that was released in Illinois. These were originally announced by executive order by Governor Pritzker on August 26th, with an effective date just 10 days later on September 5th. After significant requests for an extension due to the inability to identify vaccinated groups or even just get access to testing, these mandates now go into effect this Sunday. They got a brief 2-week extension. So there's been a lot of scrambling. So what is that current Illinois vaccine mandate? What's it look like? I've summarized the rule here in this chart. As you can see, it applies to 4 main groups: healthcare workers, school employees, college and university employees, and then college and university students. And just like the federal rule, it requires employees get vaccinated or submit to weekly testing. And the same religious and disability accommodation exceptions apply. Now, the Illinois requirement does specify exactly what proof of vaccine must be provided. So in Illinois, for those employers, the employees have to prove vaccination status by submitting one of these 3 things: the vaccine card, a picture of the card, documentation of vaccination from their healthcare provider, or an electronic health record, or state immunization records. Now, of course, any statutory definition has nuances to it. Now, in the following 3 slides, I've included the exact language on those groups that this applies to and how they're defined. What you will see consistently here is it is a very broad and sweeping definition for healthcare workers, school employees, and college employees. It applies to employees, volunteers, and those contracted to provide services for those types of entities. So I've included the definition. I won't read through them for each one, but they are here in chart form. It includes the exclusions to the extent there is one for that definition. And then of course, college and university students. This does apply to all public and private colleges, universities, community colleges, junior colleges. So very broad definition, of course, that increased the demand here in Illinois for sure. Now, based on the Illinois mandate, I recommend the same 5 steps for any chamber members touched by that mandate that we do for the federal. So of course, determine if you're covered by that mandate. Do you fall within one of the definitions? Pretty much any healthcare clinic or doctor's office is touched by that. Have you chosen what your policy is going to be? If you haven't already started, again, identifying that vaccinated, unvaccinated population that you have, seeing how many, once you've got that, evaluating your resources, policies, and procedures. And then of course, you still want, even though that rule is already in effect and has been released, still want to continue to monitor further rules from state agencies like the Board of Higher Education, State Board of Education, and of course, the Department of Public Health. The executive order does say that they could require testing more frequently than once per week, given the restraints and the limitations on testing access. I don't expect that to happen, but it has been mentioned. So just to pay attention to additional rules as those come out to make sure you're on top of that. Now, the vaccine mandate conversation is really straightforward for Iowa. There is no vaccine mandate in the state at this time. However, any employer in Iowa who's touched by the federal mandate, of course, will have to comply with that. So really cut and dry as far as that's concerned for now. And even though Iowa doesn't have a vaccine mandate, they do have a recent law regarding COVID-19 vaccines that went into effect a few months ago. And this has been referred to commonly as the Iowa Vaccine Passport Law. I know people are frequently using that term, vaccine passports, so I'm sure everyone's heard of it. And because I'm sure it impacts chamber members, we've included it today. So, what is it? It was signed into law just this past May. And the law banned local governments and businesses from requiring proof of vaccine for certain individuals invited onto their property. And it also applied to a number of businesses. Now, the law mostly impacts customer-facing companies. You think grocery stores and retailers. You'll see in this chart, by definition, it applies to businesses defined as those 1, 2, and 3s. So retailers, nonprofits, and any establishment open to the public, which includes those that require a cover charge or have membership requirements. So what the rule is essentially for any of these businesses is that they can't require proof of a vaccine, whether it be a vaccine card or something else, as a condition of entry. So I point this out today especially because the law does not expressly apply to employees. So employers can require employees to provide proof of vaccination status in the state of Iowa. And it also doesn't prohibit standard COVID-19 screening protocols, so long as you are not asking as part of that screening that someone prove that they're vaccinated. So it's definitely something to be aware of as vaccine mandates rise. And the Biden administration has announced that they're recommending large venues like sports arenas and concert halls require patrons to prove a negative test or that they're vaccinated. So we'll have to see how those kind of work in harmony together or don't. And that's kind of the end, for the summary, quick overview of vaccine mandates that apply as of today. But of course, we're still having conversations about what about those who aren't covered by this vaccine or testing mandate? What are their options? Currently, if any of my clients are on here, I'm sure they're hearing, I always say employers right now are basically falling into one of 3 buckets, and I've literally put those buckets on this slide. My blue bucket includes everyone we just talked about, somebody who's touched by a vaccine mandate, meaning they're required to require employees to be vaccinated or get tested. Now, this orange bucket means that they're not required to mandate, but they've chosen to do so voluntarily. And then the green bucket is somebody who is not mandated and they're also choosing not to mandate. So they just have absolutely no mandate in place for their workplace. As a general rule, all employers have the option to mandate the COVID-19 vaccine, so long as accommodations are reviewed for qualified religious disability reasons. And I feel like that's very, very important to note. There is no such thing as a vaccine mandate that is absolute. You will see repeatedly in federal and state language that it always says subject to legal exceptions. So what are those? You've seen those repeatedly noted on our slides today. And so Matt and I are going to kind of dive into those just a little bit because we've yet to define them. Before I do want to note that disability and religious accommodations under the Americans with Disabilities Act and Title VII, and also, of course, under state law, could be the entire focus of our presentation today. They're very dense subjects. And we're just going to cover them very generally and very directly in the scope of vaccine mandates. So any employer who is mandating vaccines will be required to review, not necessarily grant, but review accommodation requests for disabilities and religious reasons. Now, in the disability context, the employee is going to be stating that they can't get the vaccine due to a medical condition or a disability. And then in the religious belief context, the employee is going to be stating they can't get the vaccine due to a sincerely held religious belief or practice that opposes or restricts them from getting that. Now, again, the reasonable accommodation process under the ADA for disability-related requests is a topic all of its own. So for today, we don't have time for a detailed analysis of what constitutes a disability or what every major life activity might be according to our courts. But I do want to briefly review the coaching tool we use for ADA accommodation requests. So when an employee approaches management and says, today we'll just stick solely to requests related to vaccine mandates and says, I can't get the vaccine because of a medical condition I have or because of my disability, and they aren't required to use magic words. What we want management to always do is react, not overreact. We don't have suggestions for overreacting, but simply react. And that includes a 5-step process. So first and foremost, we want you to review the request, see what they are asking for. Here, it's usually going to be just being excused from the mandatory vaccine policy. Second step is evaluating if that individual has a disability. Here, I briefly put the definition up there, which is a physical or mental impairment that substantially limits a major life activity. After you've done that analysis, you are going to act by engaging in the interactive process, which generally starts with just having a conversation with the employee, and then engaging in whatever is necessary for that interactive process in that situation. Now, this is a bare minimum requirement. You can't ignore it. You can't override it. You can't skip it. So the fourth step is to conduct the direct threat and undue burden analysis. Of course, this is a crucial part. I'm going to talk about those in just a teeny bit more detail. And after you reviewed whether the employee poses a direct threat or causes an undue burden on the employer, you are then able to move on to step 5, which is where you need to tender your decision to grant or deny the exemption or accommodation. And of course, employees are not entitled to exactly what they request. Now, we all know that disability accommodations can come in all shapes and sizes, but with vaccine mandates, the request is usually quite straightforward. They're going to seek an exemption from the policy to require vaccines. So they're asking to not be required to get vaccinated. Common reasons we're seeing for these requests come through include having a history of prior adverse reactions to vaccines, having underlying health conditions that prevent the employee from getting the vaccine. And that determination is likely going to hinge on whether you're going to be providing testing as an accommodation or offering it, or whether you determine the employee poses a direct threat to themselves or others. Now, I've included the definition of direct threat on this slide. If an employer is looking to deny an accommodation request based on direct threat, that means the employer has found the employee poses a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by an accommodation. Employers cannot, as an FYI, make this determination on a universal basis. You cannot say that everyone who is a nurse poses a direct threat if they're not vaccinated. It always must include, for the ADA, an individualized determination based on the employee making the request. And ultimately, the analysis must conclude that the threat can't be diminished through other measures like routine testing. So in determining whether an individual poses a direct threat, courts and the ADA say that there are 4 main factors that need to be considered: duration of the risk, nature and severity of the harm, likelihood that the harm will occur, eminence of that harm. And again, that determination that an individual poses a direct threat has to be based on an individualized assessment of that specific employee's ability to safely perform the essential functions of the job. So this is, again, where we're saying an employer cannot say there will be no exceptions made to the vaccine mandate. There are specific steps and processes that need to be taken and concluded before any such conclusion like that is reached. Now, the last piece of the analysis looks at whether or not providing an accommodation would pose an undue hardship on the employer. And I'll tell you, as a defense attorney, this is not generally the route you're going to want to go. Undue burden is a high standard. It carries a large burden of proof. For vaccine mandates, many are looking to weekly testing as the accommodation of choice. And so for those seeking to be excused from mandatory vaccines, and unless testing or other mandates put an employer in a situation where providing testing is significantly difficult or expensive, I would look to other avenues to address that accommodation request. Now, Matt is going to talk to you about religious accommodations, and I do want everyone to make sure to note that there is an undue hardship standard under both the ADA for disabilities, and Matt's going to be talking about them in the religion context, and I would just want everyone to pay attention and note they are very different standards. Undue hardship for disability is a very high standard, and then for religious accommodations, it's a much lower standard.
Thank you. Religious accommodations should not be automatically granted or denied. Rather, the sincerity of each employee's beliefs and any potential undue hardships resulting from an accommodation should be examined each time an employee requests an accommodation. The next slide is how to handle the employee's request for a religious accommodation to a vaccine requirement. I have two and I think Allie did respect or react, I'm sorry, react as her acronym, but I was going to play on that a little bit. Employers also have an obligation to accommodate an employee's sincerely held religious belief under Title VII, unless the accommodation creates an undue hardship. A sincerely held religious belief can include an employee's religious-based objection to vaccination. The pre-step number 1, determine whether the employer is covered by Title VII, as if the ADA. All employees, including state and local government employers with 15 or more employees, are covered under the ADA and Title VII. Federal government employers are also covered by Title VII. Pre-step number 2, ensure that the policy and procedure exists for handling the accommodation. As Allison pointed out, it's very important to have that policy and make sure that the procedures for handling requests for religious accommodations. Existing job descriptions should also be reviewed to confirm they include all aspects of the job and include any requirements for mandatory vaccinations. Step 1, review requests for exemption from the vaccine requirement. Employee requests for the exemption from the vaccination requirement should be reviewed to determine if the request falls under Title VII obligations for the employer to consider accommodation. A request for exemption due to a personal preference not to receive a vaccination is not protected by law, and the employer should reiterate the company policy and the consequences for not complying with the vaccination mandate. Employees need to not use any particular verbiage when requesting an accommodation. Managers and supervisors should be trained and understand how to recognize a request for accommodation and who to relay the information within the company. Step 2, evaluate. You need to evaluate the situation. You need to be able to assume that there is more activity. There's a certain number of fly-by-night religious organizations that are outside that are scamming people for money for authorization for a affidavit stating that it's a seriously held religious belief. Make sure that you've gone through those and know what those are. Activate step 3, activate and initiate the interactive process. Similar to what Allison just said, upon learning the possible need for reasonable accommodation, employers should engage in the process in which the employee, his or her religious leader, and the employer shall share information about the nature of the religious belief and the limitations on receiving an employer-required vaccination. This process is referred to as the interactive process and involves a good faith effort by the employer and the employee to discuss the employee's specific circumstances. The purpose of this discussion is to determine what, if any, accommodations may be needed. The interactive process involves a review of the accommodation request from the employee. Neither the ADA or Title VII requires the request to be put in writing. However, having documentation of the request is a good practice. For religious accommodations, the employee should be asked to provide an explanation of his or her sincerely held religious beliefs and, if necessary, appropriate documentation from his or her religious leader regarding the religious belief that conflicts with the employer's vaccination requirement. Sincerely held belief definition is on the next slide, and that's what you want to look at. Step 4, conductive investigation, whether the employee has a sincerely held religious belief. Title VII requires employers to accommodate only those religious beliefs that are sincerely held, because the definition of the religions is broad and protects beliefs and practices with which the employer may be unfamiliar. The employer should ordinarily assume that an employee's request for religious accommodation is based on a sincerely held religious belief. If, however, the employer has an objective basis for questioning either the religious nature of the sincerity of the particular belief or practice, the employer would be unjustified in seeking additional supporting information. So this would be in the case where somebody brings you one of these fly-by-night religious organizations that give you the waiver online for $20. That's something that would tip you off to maybe go further. But sincerely held belief is not really where you want to fall. Employers should seek input from the employee's supervisor who has knowledge about the duties of the position and the work site to help determine the feasibility of what may be a reasonable accommodation, including alternative accommodations to the one requested by the employee. According to the EEOC, if an employee cannot get vaccination for COVID-19 because of a disability or sincerely held religious belief, practice, or observance, and there is no reasonable accommodation possible, then it would be lawful for an employer to exclude the employee from the workplace. This does not mean that the employer may automatically terminate the worker. Employers need to determine if any other rights apply other than under the EEO laws and other federal, state, and local authorities. Step 5, tender or notify the employee. The next step is to HR to notify the employee in writing that his or her requested accommodation has been approved or denied. If the request is denied, the employer should communicate and document any available alternative accommodations. HR must maintain all copies of accommodation requests, supporting information, and documentation, including denials, in a file separate from the employee's personnel file, consistent with confidentiality requirements and to protective sensitivity of religious preferences information. Managers and supervisors must understand that it is unlawful to disclose that an employee is receiving a reasonable accommodation or to retaliate against the employee for requesting an accommodation. Post-step, review and modify. This is one thing that people trip up on. They say, oh, we're done, we made the decision, that's it. No, you need to review the accommodation process is not set in stone and may need to be reviewed, especially if an employee's circumstances change or the needs of its business change. The next slide is sincerely held belief is not a rabbit hole you want to go down. This page and the one that follows is an overview of what traditional religious entities say about accommodation. Remember, one just has to pay for a certification online or could attend the church of body. Modification, focus on the accommodation in your analysis. The federal government has given you an out also. Look to the testing as the only accommodation. This benefits employers over under. So long as, in the meantime, the agencies promulgate a rule that address this issue. Incentives. The EEOC guidance defines agent as being an individual or entity having the authority to act on behalf of or at the direction of the employer, which could include on-site nurse, on-site medical staff, and perhaps beyond. The agency further notes that for purposes for this distinction is that if it would prefer employers to stay as far away from employee medical examinations as possible, and administering vaccines requires necessary pre-shot screening questions that could reveal information it would rather you not obtain. When an employer asks their employees whether they obtained a COVID-19 vaccine from a third party in the community, such as a pharmacy, personnel healthcare provider, or public clinic, the EEOC says the employer is not asking a question that is likely to disclose the existence of a disability. Of course, care should be continued to be taken not to ask follow-up questions, such as why the employee has not been vaccinated or whether the employee suffered side effects of the vaccine. Thus, to avoid any incentive limitation that arises in such situation, you would want to do everything you could to keep a wall up between you and the healthcare provider offering the vaccines, especially if you're setting up the vaccine clinic at your work site, to make it as easy as possible for workers to get inoculated. Unnecessary entanglements could arise if you gather medical information about your employees, assist with screening questions, or include on-site nurse or other medical staff members to aid healthcare provider in administering the shots. In a perfect world, you would limit your involvement to setting up a sign-up link to an organization, the schedule, and giving your vaccine provider access to the information generated by the link. The sign-up link and the employee-facing communications should be self-serving in this regard. You could even state that in the sign-up link that your response cannot be shared with anyone, including your employer, without your authorization. This form is not such an authorization. You may also want to consider a arm's length written agreement with the vaccine provider, confirming that they do not have the authority to act on your behalf or at your direction. So the reason we went through that whole piece on agency is if an agent performs your testing, you're going to be limited as to what you can give as an incentive. Okay, surcharge. Some employers are beginning to announce that their unvaccinated workers will soon face an increase in their health insurance premiums. Those who have made such an announcement cite rising health coverage costs as a main factor in imposing such a surcharge. Similarly to a nicotine surcharge that many employers already have in place as part of their wellness programs, you can impose an additional surcharge on the health insurance premiums for those who are unvaccinated. Before considering any health insurance surcharge, you should make sure you understand the state and federal law regarding this option. As an initial matter, any surcharge needs to be a part of HIPAA compliant wellness program. Even then, there are several requirements you must consider under both the Affordable Care Act and HIPAA before implementing a surcharge. These federal laws have specific requirements with respect to the notice to employees and also require carve-outs to allow exemptions for medical and religious reasons. You should also be mindful of any state laws which may provide protections for unvaccinated workers, as that may impact the employer's ability to charge a higher insurance premium on those who have received the shot. So that's kind of where we are with the surcharge and incentives. Allison?
Righty, we are going to go through some Q&As that we received in advance, and then we'll go through, I see some really great questions coming through in the Q&A. So we'll go through those as time permits, but feel free to throw any further questions in there. These first ones that we have on here, if I can get my mouse working, just kind of summarize what I talked about earlier, who must require vaccines in the workplace. So these first two slides, as of today, these are currently in effect. And then this second slide is going to include order announcements from, President Biden has announced that, but the individual agency rules are forthcoming. So these are the entities that should be in that planning stage, identifying your vaccinated, determining your policies and all of that. So those are a very brief summary of these first two slides of exactly who's touched by those vaccine mandates. And then briefly on masks, who must require masks in the workplace and who can't require them. So in Illinois, we're back to a all masks are required indoors. So anyone, medically able over the age of 2, on any federal employers, they're required to have a mask mandate in the workplace. And then in Iowa, there is a law in effect that prohibits mask mandates for municipalities and counties. That law originally included schools, but as I'm sure most of you have been following in the local news, especially, a federal court order from last week excluded the schools from that provision and struck that down. So that is currently in limbo. What that means is that schools can decide to mandate masks in schools. And some school districts around here, I saw Davenport just made that ruling last night. So just a brief question on masks. Can employers require proof of vaccination status? Yes, of course they can. And for those that are subject to mandatory vaccine rules that are touched by those orders, I would confirm that the proof of vaccine requirements are consistent with whatever rule applies to that business. And then for those who voluntarily choose to mandate vaccines, include in your policy what proof is going to be required or accepted so that there's no concerns for consistency or inconsistencies. Of course, we want to avoid those with policies. Are employers required to provide paid time off to employees to get the vaccine? Of course, everybody hates really annoying lawyer answers, but here's one. It depends. If vaccines are mandated by an employer, the DOL has expressed a position that time spent obtaining a vaccine that's mandated is likely compensable time. And if the vaccine is not mandated, there's no requirement to pay. Now, interestingly, the Path Out of the Pandemic Plan, which is Biden's announcement from last week, did state that OSHA will require employers, those large employers with 100 or more employees, to provide paid time off for employees to get vaccinated and then recover from side effects of the vaccine. But last week, DOL officials stated that employers could require employees to use existing PTO. So there's kind of a conflict in terms of compensable time or requiring to use accrued leave that I would absolutely pay attention to when that final rule comes out to see exactly how that.
Also, Allison, the COVID-19 and the Fair Labor Standards Act questions and answers, those first two are answered by 7 and 8. If my employer requires COVID testing during the workday, do I need to be paid for time spent undergoing the testing? Yes. Under FLSA, your employer is required to pay you for time spent waiting for or receiving medical attention at their direction or on the premises. And
Are
then
those from the live chat, Matt?
Yeah.
Okay, sorry, I didn't hear what you said at first. Okay.
Yep.
Are remote workers subject to the mandatory vaccine or test requirements? And for currently from the federal and Illinois standard, the answer to that is no. So if you have large, an entity has large remote work populations, those are not part of the current, logistical issue that you have in figuring out how to get them tested or figure out what their vaccines are. They can be excluded from that. And I've included the exact language that they have for that here. For the federal vaccine mandate applicable to large employers, how will employees be counted? I do believe we had a couple questions about that in the chat. It looks like I see 2 at least for right away. And that is on a company-wide basis. Of course, we don't have the final rule, but DOL officials did say last week in their press conference that employees will be counted under the emergency standard on a company-wide basis, as opposed to per facility. So you can start planning for that. There's no expectation that that's going to change in the final rule. If a company allows for weekly testing instead of vaccination, must the employee quarantine while the test results are pending? And the answer to that is no. The weekly testing mandate will not require individuals to stay out of the workplace until the results are received because it's considered just screening. That is obviously, of course, subject to the same risk factors and CDC guidelines or state guidance that you are following if the individual is tested based on risk factors. So if at the time that they're up for routine testing, they're reporting symptoms to you or they're a close contact, of course that changes, and then you will need to follow the applicable quarantine guidelines for that. Are companies required to address accommodations for the vaccine mandate for pregnant employees? Matt and I talked about disability and religious, and there's lots of conversations about pregnancy, pregnant employees requesting accommodations. And the answer to that is yes. Employers are required to address, again, not grant necessarily, but address requests for accommodations based on pregnancy. So if accommodations like testing are being provided to other employees for other reasons, then pregnant employees are going to be entitled to that same modification that's offered to others. And I saw a question in the chat that probably goes right along with this. Do we need to worry about exception conditions if your policy offers a testing alternative? And I would answer that very loudly, no. There's enough of a logistical nightmare, I would say, presenting employers right now. And if you are following the vax or test policy and someone has the option just to opt for testing, I would not even engage or request or solicit in any way disability or religious information, because as soon as you're put on notice of that, your legal exposure for each of those employees goes through the roof. If you're getting those in mass amounts, not only are you going to have to vet each of those, like we said before, there's no universal rule for these things. Those are individualized interactive processes and conversations. So yes, I would absolutely say if you are going vax or test, you could actually have as part of your policy, while religious and disability exceptions required by law are obviously a part of the analysis for any employer, they don't need to be a part of that one. You can simply just opt out and do the testing unless the final rules come out and limit that in any way, but we're not seeing that right now. I think the rule on federal employees is a suggestion that we're not going to see that, because federal employees specifically says you get vaccinated unless exempted by law. There's no testing component part to that. So I think the language would have mirrored that if that was going to be the intent in these final rules. Let me see if we can, I guess we're getting very close on time.
I've got one real quick one that came in. Did I understand correctly that an employer can ask for a religious leader to sign off on a religious exemption? Yes, they can ask that. If so, what do employers do about sole practitioner religions? That's the problem. Sincerely held belief. That's what the focus is on. If it's a sincerely held belief, an individual could have something very different than their religious belief, their religion belief. Okay.
I know we're out of time. I'll just answer one more real quick. Can we accept rapid results as testing, home testing, or do we need to send in for PCR? Currently, PCR tests are repeatedly stated, especially in the Illinois mandate, that they're recommended, but they're not required. So whichever vaccine mandate applies to you, if you're touched by one of those, confirm if there's a specific test that is going to be required. If not, of course, subject to your comfort level with the different levels of, reliability and such, you can use other types of test results. So I would pay attention to the final rule that applies to you. If it dictates a specific test, you're going to want to, opt for that. Otherwise, I think you have some discretion in that regard.
Thanks, Paul.
Matt, Allie, thank you so much. I would be willing, if you could, we have a few extra minutes so we can extend this. If we could get to a few additional questions. I see that some just kind of came in like, who's paying for testing, the employer or the employee? Could we try to get to most of these questions in the next 3 minutes if we do rapid fire?
Yes, we'll keep working through them.
Well,
For corporations with 100+ employees total, made up of multiple entities with separate FEIN numbers that each have less than 100, will the rule apply at the corporate level or the separate entity level? The final rule is supposed to have from OSHA specific defining regulations about that. Right now, they're saying company-wide. So I would just pay attention to the final rule on how that is. Otherwise, traditional rules on calculating employees are probably going to apply if it's silent on that, but I don't expect that it will be. Who pays for testing, the employer or the employee? In Illinois, because of the Illinois Wage Payment and Collection Act, it's a very interesting question. But if we are mandating that and it is going to inure to the primary benefit of the company, we need to look at your mandatory reimbursement policy. In Iowa, there's no similar statute for that, but in terms of requiring that, for the most part, employers are rolling out policies and they are paying for that part of it. But it does get a little bit gray in terms of how you have testing set up and the logistics of that, or free testing is available. So it's a sort of nuanced. Can employees work from home and not get tested or vaccinated? Yes, absolutely. Anybody who is not regularly accessing the workplace, in Illinois, the standard is, I think once a week, they got to meet that close contact definition on a regular basis. So if they're not in Illinois, that's the standard for that. Federal is a similar standard. If they're remote employees, they're excluded from the mandate. You don't need to have them tested. If they start coming back to the office though, and the mandates are still into effect, of course, you need to acknowledge that that population is going to be included with that. Contractor employees, are we obligated to test, or the contracting company? The contracting companies will be touched by the mandate themselves. the way that it's defined, they're going to fall within that definition. So, that's something you can work out between those types of relationships. And we've already started, of course, having lots of conversations about that.
Last
Someone
question,
decides
Allie.
to click- Oh, sorry.
No, let's do this one as the last question. I seen a lot coming in.
Okay. Let's see. If someone decides to quit their job instead of getting vaccinated, can they still collect unemployment? I would say we have seen very wild things happening with unemployment. The COVID extended reasons, what they're calling COVID related reasons. So if they find that there's, it's to no fault of the employee's own. So I would say potentially, and with the way the unemployment hearings are going right now and the way the facts are coming in, I think there's a chance for that, but we can probably get some more definitive regulation on that too.
All right. Matt, Allie, you've done an amazing job. You've demonstrated your expertise and thorough knowledge of this topic, and I know it's a fast-moving target. So thanks for your education of all of us on this webinar today. It was very valuable information as we guide the business community and each of our individual corporations through this time period. So really appreciate Pappas Wright Attorneys at Law for sponsoring today's program. This webinar again has been recorded, will be available on our website. And I also saw in the chat that we'll be providing a copy of the presentation out. There's some great information in there. Again, Matt, Allie, thank you so much for all of your work to prepare and present this today. And thank you for everybody joining us for the webinar. Hope you have a great Friday and good weekend.
Thank you.
Thank you. Have a great weekend, everyone.